Have you ever walked into a store, told the expert behind the counter exactly what obscure problem you're trying to solve, bought exactly what they recommended, and then just watched it fail spectacularly?
Oh, yeah, the absolute worst feeling.
Right. Picture it. You're standing there in the aftermath, staring at the absolute ruin of your weekend project. And you have to wonder, like, who is actually to blame here?
Oh.
Is it you for being gullible enough to buy the wrong thing?
Or is it them?
Exactly. Or is it them for recommending a product that had absolutely no business being used that way? It's a universally frustrating experience for you. You go to the professionals because, well, you don't have the answers.
Yeah, I trust them.
But when their answers are wrong, you're the one left holding the bag. Or, I mean, are you? So today, we're answering the core legal question. How does the law handle specialized product recommendations that go wrong?
It is a question that touches almost every consumer transaction we make, even if we don't really realize it. To answer it, we are going to rigorously examine a specific legal doctrine known as the implied warranty of fitness for a particular purpose.
Sounds heavy.
A little bit, yeah. For you listening, this means we are going to unpack general statutes, sections 42A to 314 and 42A to 315. And I know citing statutes right out of the gate can sound a bit dry,
Just a little.
but these are essentially the precise legal cheat codes for figuring out who pays when a project just goes completely sideways. And we aren't just going to look at these statutes in a vacuum, you know?
Right, we need real life.
Exactly. We are going to dissect the foundational case of Catania versus Brown element by element. We are going to see exactly how a court applies this seemingly rigid black-letter law to a real-world disaster.
Which is always the fun part.
Oh, yeah. In this case, involving peeling stucco, ruined walls, and some truly terrible advice.
Okay, let's unpack this. Because I think a lot of people assume that if you buy a product and it breaks, you just get a refund. End of story.
Right, the usual return policy.
Yeah. But when the product itself is perfectly fine, and it's the advice that was defective, the legal landscape shifts entirely. This isn't just a surface-level chat. This is a true deep dive into the legal source material. So let's build the foundation. What exactly is this implied warranty of fitness?
What's fascinating here is that the law actually recognizes that we don't just buy physical objects, we buy solutions to problems.
That makes sense.
Yeah. According to the Connecticut statute, section 42A to 315, and the precedent set in Crotty versus Schertenberg's New Haven, Inc., implied warranties are heavily dependent on the specific circumstances of a sale.
Okay.
So there are generally two types. The first is for merchantable quality, meaning the thing just does what it's ordinarily supposed to do. A toaster should toast bread. A lawnmower should cut grass.
Right, just basic functionality.
Exactly. The second, which is our focus today, is for a particular purpose.
Right, so like I need the toaster to survive a camping trip in the freezing rain, not just sit on my kitchen counter. If I go to an outdoor supply store and say, I need a toaster that works in a blizzard, and they hand me a standard kitchen appliance, we've crossed into particular purpose territory.
Exactly. For this particular purpose warranty to exist, the statute explicitly lays out two testable elements.
Okay, what are they?
First, the buyer must rely on the seller's skill or judgment to select or furnish suitable goods.
Got it.
And second, the seller, at the time of contracting, must have reason to know the buyer's purpose and that the buyer is actually relying on their skill or judgment.
Oh, wow.
If those two conditions are met, the warranty is born out of thin air. It is implied by the interaction itself.
So it's almost like an invisible contract writer. You don't sign a piece of paper, but the moment you say, hey, I need this to do X, and they confidently hand you the product, a silent legal guarantee attaches itself to your receipt.
Pretty much, yeah.
But what does this all mean for the seller's intent? Do we have to prove the seller was trying to scam you, or that they were just, I don't know, careless?
That's a great question.
Because usually when we talk about someone being legally liable for a massive mistake, we are looking for a bad actor, or at least someone who is wildly irresponsible.
It is entirely natural to look for a villain, you know? We want to find the malice. But that is the beauty, and for retailers, the sheer danger of this specific doctrine.
How so?
Well, the implied warranty of fitness is not founded on negligence, it is not founded on fraud, and it doesn't require a lack of good faith.
Wait, really?
Yeah. The seller could be the most well-meaning, honest, careful person in the world. But if they give the recommendation and those two elements are met, they are on the hook.
That is wild.
It is. The liability arises purely from the transactional dynamic. You informed the seller of your specific conditions, you trusted their professional judgment, and they sold you the product based on that trust.
That is a massive shift in how we usually think about blame. It's not about malice. It's about correcting an information imbalance, right?
Precisely.
The law is essentially saying that in a complex modern economy, consumers can't be expected to have a PhD in every single product they buy.
We just can't.
We have to be able to trust the experts, and the law protects that trust.
Yeah.
So, to really see how a judge actually looks at this, we need to look at the Catania case.
Yes, let's do it.
I want to structure this carefully so we don't miss any of the nuance. For those unfamiliar, we are going to use a structured fire act method. That stands for facts, issue, rule, application, and conclusion.
It's the standard.
Yeah, it is the diagnostic tool lawyers use to take a messy, real-world problem and run it through a legal filter. So let's analyze Catania versus Brown. First, what are the legally dispositive facts?
The legally dispositive facts, meaning the specific details that actually make or break the case, are straightforward but incredibly specific.
Okay.
Michael Catania, the plaintiff, asked the defendant who owned a retail paint business to recommend a paint for the exterior stucco walls of his house.
Pretty standard so far.
Right. But crucially, Catania explicitly told the business owner that the stucco was currently in a chalky and powdery condition.
Ah, specific words, chalky and powdery.
Yes. The seller then recommended a product called Pierce's Shingle and Shake Paint. He gave Catania specific instructions: wire brush the flaky loose particles, mix 2 or 3 gallons of the paint in a container, and add a thinner.
And Catania did all that.
He followed these instructions to the letter. But 5 months later, the paint peeled, flaked, and blistered right off the house.
Oh, man.
Yeah. The underlying reality was that the condition of those walls actually required intensive sandblasting before any paint could adhere, not just a simple wire brushing.
So Catania has a ruined house after months of staring at peeling paint. And what was the core legal issue?
The specific issue before the court is whether the paint retailer breached an implied warranty of fitness for a particular purpose when his specifically recommended paint failed on the buyer's specifically described walls.
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule from General Statutes, Section 42A to 315. The rule dictates that an implied warranty of fitness arises when 2 distinct elements are satisfied.
Okay, lay them out.
First, the seller must have reason to know the buyer's particular purpose and that the buyer is relying on their expertise. And second, the buyer must actually rely on the seller's skill or judgment to select the goods.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the seller's knowledge of purpose and reliance?
We can do a mini IRAC on this first element alone. So the sub-issue here is, did the seller know what Catania needed and that Catania was relying on him?
Okay.
The sub-rule defining this element is that knowledge is established if the buyer informs the seller of the unique circumstances and conditions necessitating the purchase.
So they have to actually tell them.
Yes. When we look at the court's application of the specific facts to that sub-rule, we see that Catania didn't just walk in and ask for generic exterior paint.
Right, he used those words.
Exactly. He explicitly described the unique problematic condition of his walls as chalky and powdery. By bringing this specific problem to a specialty retail paint business owner, he signaled his reliance on the owner's expertise to solve it.
That makes total sense.
So the court's conclusion on this element was clear. The first element was unequivocally met because the unique conditions were communicated, and the seller understood he was being asked to provide a specialized solution.
Wait, so just to clarify, if Catania had walked in and just said, hey, give me 5 gallons of your best exterior paint, and the guy handed him the Pierce's Shingle and Shake, the seller likely wouldn't be liable here.
Precisely.
It's specifically the fact that he used the words chalky and powdery that traps the seller.
Yes. If he just asked for exterior paint, the seller only warrants that the paint is fit for standard exterior walls. That's just merchantability.
Got it.
The particular purpose was the chalky nature of the walls. Because Catania communicated that, the seller's knowledge was triggered.
Understood. Now what about the second element, the buyer's actual reliance?
Moving to the second mini-IRAC. The sub-issue is, did Catania actually rely on the seller's expertise instead of his own judgment?
Okay.
The subrule dictates that a buyer's ignorance of the fitness of an article justifies their reliance on the superior information, skill, and judgment of the seller.
So if you don't know anything, you're allowed to trust them.
In plain English, yes.
Yeah.
If you are totally ignorant about what you're buying, the law says you are completely justified in leaning entirely on the seller's expertise.
Wow.
In application, the court looked closely at Catania's actions. He didn't second-guess the seller. He bought the exact brand of paint recommended.
And he followed the prep steps.
He used the exact thinner recommended, and he followed the wire brushing instructions perfectly. He completely surrendered his own judgment because he had none regarding chalky stucco, and substituted the seller's judgment for his own.
So what did the court decide?
Therefore, the conclusion for this element is that actual reliance was proven. The second element was met.
So to put that in perspective, if Catania had gone home, watched a YouTube video on stucco repair, and decided to skip the wire brushing step because he thought he knew better, the seller is completely off the hook.
Absolutely.
Even if the paint was still the wrong recommendation.
Absolutely. The moment the buyer substitutes their own judgment for the seller's, the actual reliance is broken. The warranty dissolves. But Catania followed the bad advice perfectly.
And after analyzing all the elements, what was the court's final conclusion?
The ultimate holding of the court was that there was no error in the lower court's ruling in favor of the buyer.
Makes sense.
By synthesizing the elemental analysis, the court concluded that because Catania communicated his particular purpose and justifiably relied on the superior skill of the seller, who provided a faulty recommendation, the implied warranty of fitness was properly claimed and breached.
That structural breakdown makes it so clear. It just strips away all the emotion, all the frustration of the ruined weekend project, and just looks at the cold mechanics of the conversation.
It really does.
But it makes me wonder, like, how far this rule stretches. Does this apply to everything? I mean, if you're listening to this and thinking about that time a plumber recommended the wrong fixture, or a mechanic recommended the wrong tires for your specific commute, this is the exact legal test you'd have to pass.
Exactly.
The Catania text cites a few other precedent cases that I think map out the boundaries of this doctrine. How does this rule apply to other types of goods? Let's talk about the Friskin and Handy cases.
So the citations the court uses are perfectly chosen to show both the reach and the limits of the rule. For example, they cite a case called Friskin versus Art Strand Floor Coverings, Inc., which involved asphalt tile.
Okay, floor tile.
Yeah, and in that scenario, the buyer needed tile for a very specific type of damp floor. They also cite Handy versus Holland Furnace Kerma, which involved a thermostatic fan for a furnace.
Those sound pretty technical.
They are. Furnaces are highly complex, interdependent systems. In both of those cases, the courts readily found that actual reliance existed because the retailers recommended specific, highly technical items for specific, unique home setups.
I see.
When a retailer says, take this specific fan for your specific furnace, the warranty attaches almost automatically because the knowledge gap between the buyer and seller is just so vast.
Okay, so highly specific goods, clear reliance. But then they cite the Houston Starco case, which seems to draw a hard boundary. What happened there?
Yes. Houston Starco versus Berea Brick and Tile Co. shows exactly where this doctrine stops. In that case, the seller sold what are known as cull bricks.
Cull bricks, what are those?
Cull bricks are essentially defective, discarded, or rejected bricks. They are cheap and they have uses, but they are not meant for serious structural work.
Gotcha.
Well, the buyer purposed these cull bricks and used them for the exterior of a home, exposing them to the weather. Naturally, they failed. Right. But the court ruled there was no implied warranty of fitness here. Why? Because the seller never warranted that cull bricks were fit for exterior home construction.
Oh, I get it.
The buyer completely failed the first element. They didn't establish that particular structural purpose with the seller beforehand, and they certainly couldn't prove the seller knew they were relying on them to build a house out of trash bricks.
Right. You can't just buy a pallet of literal garbage, use it to build a weather-facing mansion, and then drag the seller to court when it all falls down.
No, you definitely cannot.
The law protects the ignorant, but it doesn't protect the absurdly reckless who fail to communicate. You have to actually tell them what you were doing.
Exactly. Communication is key.
Okay, I want to really test the boundaries of this with a hypothetical.
Right.
I want to make sure we understand exactly how rigid these elements are, even in completely bizarre situations.
Lay it on me.
So picture this. Imagine you are a specialized transporter, and you have been hired to move a rare, incredibly dangerous, acidic, slime-excreting swamp slug.
Naturally. A completely standard logistical challenge.
Right, just a typical Tuesday in the transport business. You go to a specialty exotic pet store, you walk up to the counter, and you explain the exact horrific nature of this slug to the owner.
Okay.
You detail the pH level of its acidic slime, you explain how it routinely eats through solid metal, and you ask the owner for a specialized heavy-duty containment unit.
Sounds very thorough.
The store owner, brimming with completely unearned confidence, recommends a standard corrugated cardboard box. You, despite every alarm bell going off in your head, decide to trust this expert. You buy the cardboard box, you put the slug inside. 10 minutes later, the slime meets the cardboard, the slug escapes, and your car's interior is completely dissolved into a puddle of foul-smelling goo.
What a mess.
Structurally, using the strict elements we just covered, who is liable?
It is a brilliantly disgusting hypothetical, and it perfectly illustrates the ruthless, mechanical logic of the law. Let's break it down using the exact elements we just discussed.
Let's do it.
In this scenario, the store owner might not have been actively malicious. There's no fraud here. He didn't trick you.
Right.
He might not even be strictly negligent if, in his own mind, he genuinely believed it was a really good, sturdy cardboard box. But under the doctrine of the implied warranty of fitness, none of that matters. The warranty is absolutely breached.
Wait, really? Even though any reasonable person on planet Earth would know, a cardboard box cannot hold a monster that secretes acid slime. Does the buyer's own stupidity not disqualify them?
It doesn't, because the law focuses entirely on the specific transactional elements, not on general common sense. Look at element 1. Did the seller know the buyer's purpose and reliance?
Well, yeah. I explicitly stated the particular disgusting circumstance.
Exactly. The acidic slime and the metal melting pH level.
Yeah.
And you specifically asked for a solution. Now look at element 2. Did the buyer actually rely?
I mean, I bought the box.
Yes. Despite your better judgment, you bought the terrible recommendations, suppressed your own doubts, and put the slug in the box.
That's crazy.
The fact that the advice was objectively, laughably terrible doesn't protect the seller. In fact, it is the very basis of the breach.
Wow.
Because you stated the specific conditions, and because you surrendered your judgment to their supposed expertise, the seller assumed the entire risk of that transaction. They impliedly warranted that the cardboard box was fit for the particular purpose of holding an acidic swamp slug.
And it obviously wasn't.
It obviously wasn't. They owe you a new car interior.
That is wild to think about. It basically means that in commerce, if you hold yourself out as an expert, you are legally writing a blank check with every recommendation you make.
That's exactly what it means.
You cannot just guess to make a sale. If you don't know the answer, your safest, smartest legal move is to just look the customer in the eye and say, I have absolutely no idea.
Precisely. The law demands intellectual honesty from merchants. So if we connect this to the bigger picture and synthesize everything we've covered, here is your step-by-step diagnostic checklist.
Oh, this is great.
Yeah. If you are ever taking an exam or navigating a real-world dispute, use this framework to spot the issue. Step 1. Identify the transaction type.
Like, is someone actually buying a good based on a specific recommendation?
Yes. If the buyer just walks in, ignores the staff, and pulls a product off the shelf themselves, this specific warranty likely does not apply.
Got it. What's next?
Step 2. Check the communication. Did the buyer clearly and expressly state their particular purpose or unique circumstances?
So did they mention the chalky stucco or the acidic slime?
Exactly. General, everyday usage isn't enough. The communication must highlight the particular unusual need.
Right.
Step 3. Assess seller knowledge. Did the seller know, or should they have reasonably known based on the conversation, that the buyer was relying entirely on their expertise to select the correct product?
Okay, that makes sense.
Step 4. Verify actual reliance. Did the buyer actually follow the advice to the letter? This is the most crucial step.
Because if Catania had listened to the seller's recommendation but then decided to buy a completely different, cheaper paint,
Or skipped the prep work.
right, then the claim completely fails. The reliance must be actualized through action.
Perfect. And finally, step 5. Rule out irrelevancies. When analyzing the breach, remind yourself that you do not need to prove negligence and you do not need to prove fraud.
So don't get distracted by looking for a bad actor with malicious intent.
Exactly. The warranty exists and is breached simply because of the reliance on superior information that turned out to be wrong.
Here's where it gets really interesting. Think about how often this precise scenario plays out in your own life.
All the time.
Think about every time you walk into a massive big box hardware store on a Saturday morning. You flag down a teenager wearing an orange apron, you hold up a weird, rusted piece of metal you pulled out of your wall, and you ask them exactly what kind of pipe you need to fix the plumbing under your sink.
Oh, we've all been there.
They nod confidently, hand you a PVC pipe, you buy it, and you install it. How much of our modern, incredibly complex consumer lives are held together by these invisible, unwritten warranties of trust?
A huge amount.
We are constantly venturing into fields we know nothing about. Every time we step out of our depth and ask an expert for help, the law silently weaves this safety net underneath us to keep commerce moving.
Mm-hmm.
So the next time you rely on the expert behind the counter and you explain your very specific, very obscure problem to them, remember that you aren't just having a casual conversation. You might just be forming a legally binding implied warranty of fitness. Keep that in mind next time you ask for advice.